I'm Liz McGill. I welcome you back to Stanford Law School. We're delighted so many of you have come here. I hope you're in for a great weekend, the start of the great weekend, and many of your classmates are back and you enjoy the many events that your classmates have put together and organized. This lunch is a faculty spotlight lunch, so we're going to hear brief bits from three superstar members of our faculty. I know you will be delighted to hear from them. I wanted to just say a few words about what's going on at the law school. I don't know the last time many of you have been here. I know some of you have been here 6 months ago, 9 months ago. Some of you may not have been here for 5 or 10 or 15 years. And if it's been that long, you will notice that a lot has changed at Stanford Law School. Not just one big change is the physical plant. If you have not walked around the Munger residences or the Newcomb building, I encourage you to do so. What some of you think of as the new law school building, the one that opened in the 70s, and the Newcomb building and the Munger building, those three buildings together create, I think, a kind of campus for the law school that really reinforces the intimate community we have here. It's really been, I think, transformative, the addition of Munger and Newcomb. Much has changed inside the building as well. Our faculty and our students are going in and out of the law school to other parts of campus in a pretty seamless way. Last year, our students took 590 classes outside of the law school. In engineering, in economics, in the Graduate School of Business, and the Graduate School of Education. The law school is very much a part of the puzzle of Stanford University, which is the way it should be. The parts make a greater whole than the individuals. I've said about 100 times this year since I've gotten to know it, I think we have the best clinical program in the country. If you don't have a sense of the clinical program, please learn about it. I would love to give you a tour of the beautiful clinical space on the first floor of Newcomb. We have 11 different clinics, all different practice areas. Students doing litigation, but students also doing organizational and transactional work. Supreme Court litigation clinic, immigration clinic, environmental law clinic. New this fall is an intellectual property and innovation clinic. These are clinics that are providing an amazing professional education for our students. We have a couple of new initiatives too. We're doing some work to expand the public policy opportunities our students have. We launched this year a policy lab where students are working with faculty on projects that range from healthcare to criminal justice for an outside client, say a California Law Review Commission or a Register of Copyrights, to work on a problem that that individual has that needs the analysis and analytic power that Stanford students and Stanford faculty can offer. We're also working to expand our global footprint. Law, as you all know, is by nature a parochial discipline. It's jurisdictional. The law of Ohio is different from the law of North Dakota. That's pretty parochial. But globalization, of course, has changed the nature of practice of law. We're trying to do more. We have been working, but we're trying to expand the opportunities for our students to experience that. So a lot has changed. For many of you, this is not the law school you went to. It's a different experience, and I encourage you to learn as much about it as you can. We have some current students here, some eyewitnesses to what happens at the law school today. But there are some things that have not changed at all. We remain a small community of faculty and students working together. We remain an egalitarian, very non-hierarchical place. We remain a place that is affected by Silicon Valley, and if students don't like the way something is being done, they just decide they're going to change it. I talked last year to a group of students who thought we weren't doing enough work in the community, so they just created a new event, which was wildly successful. Another thing that has not changed is that we spend a lot of our energy trying to find talent. We spend a lot of our energy trying to find the best students in the world, admit them, and try to get them to come to Stanford. We spend a lot of time evaluating faculty, give them an offer, and try to get them to come to Stanford. We have two incredible pools of talent in our students and our faculty, and that's the core of this institution. So that's the reason we wanted to get some of our faculty before you today. Jenny Martinez is going to start. She's a professor of law and Warren Christopher Professor in the Practice of International Law and Diplomacy, and she's also the Associate Dean for the curriculum. She's a leading expert on international law, international courts, international tribunals, constitutional law, the law of war. Her first book was a quite important book that made us all understand the actual origins of modern human rights law. A very unfair summary of it would be, it's not Nuremberg, it's much further back than that, origins in the slave trade. Jenny teaches courses in constitutional law and many different international courses. She's going to talk today about Bond versus United States, a pending Supreme Court case on treaties and the US Constitution, for which she recently wrote a historian's brief. And that's a good segue to be able to say something that's not on the resume about Jenny. She's litigated some cases. She'd argued cases in the Supreme Court. She's a fabulous scholar. She is what you would call an utility infielder of the faculty. So we're delighted to see her here today.
So Oliver Wendell Holmes famously said that great cases, like hard cases, make bad law. But what about small and slightly ridiculous cases? Today I'm going to tell you about one such case, Bond versus United States, which is currently pending before the Supreme Court, and which the court has been asked to overturn a 90-year-old precedent about the scope of the federal government's constitutional power to enforce international treaties. As Liz said, I filed an amicus brief in the case on behalf of legal historians and was aided in the drafting of that brief. Really, it was written by 3 of my intrepid students from Con Law 1, who in the course of last winter's quarter had done a mock oral argument in the case, and then this summer helped me draft the amicus brief, along with one 2L student in the International Human Rights Clinic. So the case began in 2005 when Carol Ann Bond learned that her best friend, Merlinda Haynes, was pregnant. Bond was initially thrilled for her friend, until in soap opera-like fashion she learned that the father of the child was her own husband, Clifford. Less happy, Bond vowed to seek revenge, and since she was a scientist, her planned revenge took an unusually sophisticated form. First, she stole a particularly dangerous form of arsenic from her employer, a major chemical manufacturer. If swallowed, 1/2 teaspoon of this would be lethal to an adult, and a few crystals could kill a child. Not wanting to leave anything to chance, Bond also ordered another highly toxic chemical, potassium dichromate, on Amazon.com. Inhaling a small quantity of potassium dichromate can cause life-threatening damage to the respiratory tract, but because the chemical is widely used in photo processing, any one of us here could purchase it right now on Amazon in lethal quantities for the low, low price of $8.95. Apparently, most photographers know better than to inhale their developer chemicals. Having procured these potentially lethal tools, Bond then went about her revenge in a completely half-hearted way. She did try to poison her ex-best friend on 24 separate occasions, but she didn't try to sneak the chemicals into her food like those elderly aunts in Arsenic and Old Lace. Instead, she sprinkled the chemicals around Haynes's home and car. This wasn't a great plot. The chemicals were quite noticeable. Potassium dichromate is bright orange. And Haynes was smart enough not to lick her hands after touching it. And so in the end, the only damage she actually suffered was a small chemical burn to one of her thumbs. During the course of these attacks, Haynes did call the local police. When she found the powder on the door of her car, she called them. They came, not being familiar with chemistry. They were a bit confused. They suggested that maybe it was some kind of cocaine and advised her to take the car to the car wash. When the chemicals appeared on Haynes's mailbox, the police then suggested that she call a federal postal inspector. And in this way, the case eventually made its way to a federal prosecutor. Unlike the local police, the assistant United States attorney assigned to the matter took a great interest in Bond's crimes, indeed perhaps a little too much interest, and Bond was soon charged in federal court with violating 18 U.S.C. 229A, the federal statute implementing the 1993 UN Chemical Weapons Convention. This somewhat obscure treaty has recently earned headlines because the United States threatened to bomb Syria when its President Bashar al-Assad was alleged to have used chemical weapons against civilian targets. And just last week, the organization that enforced the treaty won the Nobel Peace Prize. But back in 2007, when this case was brought, the assistant U.S. attorney assigned must have spent quite some time digging around in the statute books to come up with this one. But charge her under it he did, and the statute forbids the knowing possession or use for quote-unquote non-peaceful purposes of a chemical that can cause death, temporary incapacitation, or permanent harm to humans or animals. The law was designed to implement the U.S.'s obligation under this important international treaty to prevent all use of chemical weapons by U.S. nationals, including by non-state actors or private individuals. So think terrorists with sarin gas. Bond's lawyer moved to dismiss the charges on the grounds that Section 229 unconstitutionally violated principles of federalism by infringing on the power reserved to the states under the 10th Amendment to the U.S. Constitution. Now, I teach in our first-year curriculum, and I'm used to calling on people, so I'm tempted to call on some of my students right now to ask them what the 10th Amendment says, but I won't put them on the spot. And I'll tell you, in case you've forgotten, that it provides that the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. Now, the most common basis for delegated federal legislative power is, of course, the Interstate Commerce Clause. One might think that the fact that Bond had ordered some of the toxic chemicals on Amazon would make it a pretty easy case for interstate commerce. But the very creative assistant U.S. attorney assigned to the case decided to disclaim any reliance on the Commerce Clause, a disclaimer the government now regrets and is trying to retract, and rest his argument solely on the treaty clause of the Constitution combined with the necessary and proper clause. The district court denied the defendant's motion to dismiss, relying on the Supreme Court's 1920 decision in Missouri versus Holland. Here again, I'm tempted to call on some of my students, but I won't. And Bond pled guilty, reserving her right to appeal on the federalism issue. Now, the 1920 case of Missouri versus Holland, does anyone remember that case? Other than my students? All right. So the 1920 case, Missouri versus Holland, concerned the validity of the Migratory Bird Treaty Act of 1916, a landmark piece of legislation. So at that time, this was before the New Deal understanding of the Commerce Clause changed, and the Commerce Clause as interpreted by the courts was quite narrow, and indeed lower federal courts had struck down previous attempts by Congress to protect endangered migratory birds as being outside Congress's commerce power. So what did the government do? Well, the federal government decided to try to get around that limitation by negotiating a treaty on migratory birds with Canada. And then Congress passed a statute implementing the new treaty. This was challenged by the state of Missouri on 10th Amendment and federalism grounds, the exact same argument that Bond makes in this case. And the Supreme Court upheld the statute against that federalism challenge, even at a time when federalism was quite dominant in the court. And writing for a 7-justice majority, the ever-quotable Justice Holmes said that to answer this question, it's not enough to refer to the 10th Amendment, reserving the powers not delegated to the United States, because by Article 2, Section 2, the power to make treaties is expressly delegated. And by Article 6, treaties made under the authority of the United States, along with the Constitution and laws, are declared the supreme law of the land. If the treaty is valid, there can be no dispute about the validity of the statute under Article 1, Section 8, as a necessary and proper means to execute the powers of government. So as the amicus brief authored by my students and myself on behalf of legal historians explains, Justice Holmes' opinion was not rendered in the dark, but rather in light of a long history of debates about states' rights and the federal treaty power. Under the Articles of Confederation, state noncompliance with treaties had been a serious problem and was one of the main causes of the calling of the Constitutional Convention. In the early republic, the Supreme Court upheld the supremacy of treaties over state property and contract law. Southern states in the period before the Civil War raised states' rights objections to the federal government's claim that the Treaty of Amity and Commerce with Great Britain prevented or prohibited them from imprisoning black British sailors under the so-called Negro Seaman Acts, But Supreme Court Justice William Johnson, writing Circuit, rejected those Southern states' rights argument on the grounds that accepting it would render the Union, like the old Confederation, a mere rope of sand. Here in San Francisco, around the turn of the 20th century, a plan by the city government to segregate Asian children in public schools that were separate from those of white children was criticized by the government of Japan as a violation of our Treaty of Amity with that country, but defended by local officials on federalism and 10th Amendment grounds, generating several books and a number of scholarly articles about the constitutional question. And so by the time Missouri versus Holland was decided in 1920, the arguments about federalism limits on the treaty power had been repeatedly and publicly aired, and so the court's decision was certainly not an ill-informed one. And so the precedent of Missouri versus Holland has stood for the past 90 years, aside from an unsuccessful attempt in the 1950s to overturn the case by way of constitutional amendment, based on concerns at the time that new international human rights treaties enacted in the aftermath of World War II could be used by the federal government to attack racial segregation in the South. But as many of you will know, federalism has enjoyed a resurgence in Supreme Court decisions in the past 2 decades. And the facts of the Bond case bring it within the land of hard cases, if not great ones. The case was before the court 2 years ago, at which time the court unanimously found that Bond did have standing to raise the 10th Amendment argument. And this time Bond has explicitly asked the court to overrule or at least sharply limit Missouri versus Holland. The court is clearly troubled by the case. As Justice Alito worried at oral argument last time the case was before the court, suppose that the petitioner in this case decided to retaliate against her former friend by pouring a bottle of vinegar into the friend's goldfish bowl. That conduct falls within the literal terms of the statute, but seems a scant basis for federal interest. On the other hand, as Justice Alito also wondered at the last time the case was before the court, doesn't the federal government have a real interest in any use of something like sarin gas? So where's the line between terrorism and soap opera, between war crimes and lovers' spats, and who should decide where that line is drawn? The court may well dodge the issue, though its decision to grant cert twice in 2 years suggests an interest that goes beyond Ms. Bond's short stint in federal prison. The Chemical Weapons Convention is a serious treaty, but the soap opera-like facts of the Bond case may make for some dramatic changes to long-settled principles of constitutional law and limit the federal government's power to enforce international treaty obligations. Whether that's good or bad depends, of course, on your perspective. But in any case, it seems that at least one of Justice Holmes' sayings may be up for revision. Thanks.
Thanks, Jenny. It's my pleasure to introduce Bob Weisberg to you. Bob is a 1979 graduate of the law school, so I know many of you know him. He's the Edward Huddleston Professor of Law. He also co-directs the Stanford Criminal Justice Center, which coordinates and promotes research on policy in criminal justice. Before joining the faculty, Bob was at the NAACP Legal Defense Fund and the California Appellate Project, where he worked on death penalty litigation in the state and the federal courts. When Bob was at the law school, he was editor of the Stanford Law Review. Since he's been on the faculty, he's a 2-time winner of the Hurlbut Teaching Award. So he's addressed the graduating class as a result of that. I've met many alums in my travels this last year who had Bob as a teacher. I've met some alums who were in Bob's class. The students, the former students uniformly say that Bob made them interested in criminal law even when they didn't know that they were before they knew him. And many of his classmates have told me that, you know that feeling when you survivor's guilt, you know, when you're in a room and you think, gee, how did I get into this room? Well, that's a feeling many first-year students have when they're just starting out and they meet their Stanford Law School classmates and they think, how did I get in here? Many of them feel that way. Bob was one of the people in that class who made many of his classmates feel that way because he had a PhD and had taught before he came to law school. So Bob's devotion to his classmates, but also to his students over the years is only matched by his intrepid, determined commitment to marathoning. So, Bob.
I'm a very slow marathoner, so I'm not at all familiar with this very, very tight format we're operating under here. The bad news is that no law professor could say anything in 8 minutes. The good news is that at least I'm from New York, so I can get a lot of words out very, very fast. Okay. The key word here is a word which is very current, very au courant in criminal justice matters these days, recidivism. I, along with my colleagues, Joan Peter Sillia and Debbie Muckamal, run, as the Dean mentioned, an entity called the Stanford Criminal Justice Center. We're a research program that basically examines what works and what doesn't work in criminal justice in the United States. And at a time when crime is down, and therefore some of the political demagoguing over crime has abated, there's a fair amount of reconsideration of criminal justice systems going on in the country right now, and some very constructive reform efforts. So what are we really talking about? Well, let me just crudely set aside one possible argument, which is that the purpose of criminal punishment or a criminal justice system is to ensure proper moral retribution for malefactors. It's a perfectly legitimate, time-honored Kantian basis of criminal justice, but let's face it, most people are really utilitarians when it comes to crime. So the question is, how can a criminal justice system serve the purpose we're really concerned about, which is reducing crime? Well, the best thing would be if a criminal justice system simply prevented people from committing any crimes in the first place, and we wouldn't even have to use this complicated word, recidivism. Well, of course, what might prevent people from committing crime could be all kinds of things entirely independent of a criminal justice system, schools, family, whatever, but let's talk about criminal justice systems. If our goal is to prevent people from becoming criminals in the first place, this is what, of course, legal types talk about as general deterrence. Pass a law, announce a punishment, and hope that people are so scared at the prospect of the consequence of punishment that they'll never commit the crime. Okay, general deterrence is tough to measure, and it only goes so far. It probably operates pretty well, except there's always the question of marginal general deterrence. Since the U.S. now has, by far, the highest incarceration rate in the world, and by some measures the harshest sentences for common crimes in the world, it could be that we've already gotten all the general deterrent bang from the buck that we're ever going to get. Okay, if that's true, let's really talk about what criminal justice systems do. They take in and they process criminals. They give them whatever they deserve by any other measure, but the main concern is that when they get out, which 99% of all criminals do, that they don't commit more crimes. In other words, it's not exactly preventing crime per se, it's preventing recidivism. And it's a very hot word these days. By the way, unfortunately, an otherwise extremely fine recent head of the California Department of Corrections had a really hard time with this word, and I think one of the reasons he resigned early is that he kept saying recidivism, and nobody knew what he was talking about. Okay. Now, assuming that you're a bad guy and you're in jail or prison, what can we do to prevent you from recidivating, which is a horrible verb, but there it is, okay? Well, then you talk about the utilitarian purposes of crime. One of them is incapacitation. Hey, the good thing about that is that that addresses recidivism pretty directly. Putting aside the possibility that bad guys commit crimes in prison, which they do all the time, but let's not worry about those victims, it is often said, then we prevent the recidivism that would have occurred during the time that they're in prison had they not been in prison. Okay, that's just kind of circular, okay? But even if nothing else happens to them in prison other than that they don't commit any crimes outside prison during that time, well, in a way, incapacitation serves to reduce future recidivism for one simple reason. They're older when they get out, okay? And it depends how long they're in. But if you put a 22-year-old fellow in jail and you let him out 20 years later and you have done nothing to improve his moral character or change his view of consequences, you're still going to have drastically reduced his possible rate of recidivism because, well, let's put it this way. How many 43-year-old running backs are there in the National Football League, okay? Yes, I suppose he could still commit insider trading. You don't need great legs for that, but most of the crimes we worry about, not. Okay, thank you, okay. And Joe agrees with that. Okay, fine. Now, that leads to something, and that is to say that there is an age crime curve, and it peaks for a while, but then it goes down very rapidly, okay? But let's assume that that's really sometimes just immutable. Some people are going to commit a lot of crimes up to a certain age, and then commit more crimes, but it's go down a bit. Let's talk about the things that are really designed to make use of imprisonment to reduce recidivism. One would be so-called specific deterrence, not general deterrence, but specific deterrence. You're in jail, and you're scared straight by the experience of being in jail. When you leave jail, you're going to think more of the consequences. You're less likely to commit crime. Second, and it's really a flip side of specific deterrence, rehabilitation. You did a bad thing, you're in jail, and you're in jail because you're a kind of rotten person, and the jail experience turns you from a rotten person into a good person because of moral enlightenment, education, whatever. Sometimes that's a little hard to distinguish from specific deterrence. After all, sometimes you can be kind of scared of the consequences of being a bad person, and you become morally enlightened. Okay. Now, let's all agree then that criminal justice systems should try to reduce the amount of crime you commit afterwards. The big thing is, since we all know that's the goal and we know it sometimes happens, how do we measure it? Because public officials are always imposing accountability on themselves or having accountability imposed on them with the goal of finding out whether the thing is really working. The system is really working, and the way the system should work well is to reduce recidivism. So right now, at a time of a lot of reform, there's a big debate about exactly how to measure recidivism. And I'm just going to offer a few quick thoughts on the challenge and the difficulty of this, okay? Number one, what will count as a recidivist act afterwards? You might say, well, if you commit a crime when you get out. Well, that depends on how serious a crime you commit. It depends on when you commit it or how frequently you commit it. If the goal of anti-recidivist policy is to ensure that nobody commits any crime thereafter, you can assume failure. So maybe the question should be, given the likely age curve of your crime trajectory, have we succeeded in reducing recidivism if you commit somewhat less crime, somewhat less serious crime, or crime less frequently than you would have had you never been in prison, which is an interesting way to measure it, okay? So that's one thing. Another thing, though, is what is this business about crime? After all, I could probably greatly reduce recidivism as a legislator or a governor if I repealed a lot of the criminal laws going down the road, because then fewer people would have committed crimes. On the other hand, I can greatly increase recidivism if I, upwardly arrange laws. Now, let me give you, just to kind of focus on this for a second, an example of a very interesting proposal which is being batted around among California officials. Recidivism defined. It doesn't trip off the tongue, this thing. This is not a sonnet or a villanelle. It's bureaucracy. Okay. Recidivism is defined as a qualifying return to custody during a specified time period. Qualifying returns include new arrests, convictions, revocations. Custody includes jail, prison, other alternative sentencing options such as fire camp, electronic monitoring, imposed in lieu of jail or prison following a qualifying return event. Specified time period is a period of 5 years from a subject's release from custody. The specified time period shall continue to run regardless of supervision status, i.e. whether a subject is on probation, parole, post-release community supervision, and so on and so on. Now, there's a lot packed into this, but I just want you to focus on what's interesting there. First of all, to start at the end, it has a time period. So in that sense, if the guy doesn't recidivate for 5 years, the fact that he might recidivate later, oh please, come on. The system worked pretty well, so let's not be too hard on ourselves, okay? You could add to this, though this doesn't, the idea that as long as, again, he's producing fewer crimes or less serious crimes, even during that 5-year period, hey, it worked to some extent, okay? But the other part of this, of course, includes the question of when you start measuring from, and more significantly, what is the recidivist act? And you notice there's a big focus not on being busted for a crime, which would certainly do it, but being returned to custody for various types of revocations. And here is the real problem with the definition. Let me just go back to some California news a couple of years ago. As many of you may know, we in California, or official fake Californians like myself, I've been here 30 years now, okay, are proud of the fact that we're #1 in everything, and of course we lead the nation in the dysfunctionality of our criminal justice system. We actually don't have the highest crime rate, we don't have the highest imprisonment rate in the state, but we were said to have the highest recidivism rate. That was certainly true if you define recidivism as being in the state prison, leaving the state prison on parole, and doing something that got you back in state prison. The problem with that is it would be one thing if what got you back in state prison is committing a whole new crime. Boy, that's recidivism. The problem, though, is that under the California rules, which have changed to some extent now, you could be held in violation of a condition of your parole, or let's say, supervision in some other language, and that might send you back to prison. This could produce both an overcount and an undercount of recidivism in the following sense. Here's the way it could produce an undercount. If you prefer to define recidivism as being convicted of a new crime, prosecutors who find a former prisoner who has committed a new crime may want to send them back to prison, but it takes a lot of work to send them back to prison. You have to indict them, you have to give them a trial and all that. I know, call the new crime a technical violation because, it's always a condition of parole that you not commit new crimes. So we send them back to prison, but it doesn't count as a crime. Okay? Flip it around, though, under the California rules, you do something which is not a new crime, but it is a violation of your conditions of parole, like you don't show up for your drug test, you leave town without permission and all that. That sends you back to state prison. Is that recidivism? Well, you could define it that way, but that's not a new crime. So, if I were a postmodern structuralist, post-structuralist, a literary theorist, I would say, aha, recidivism is essentially socially constructed. Okay. Well, I guess if I were an economist, I'd say it's endogenous on the system or something like that. In any event, then, it is both difficult to define recidivism and difficult to measure it. Here's the key takeaway. First of all, probably the most important thing we have to do is to come up with any workable definition, but make sure it's used consistently. Otherwise, we're going to have political sound bites talking about the recidivism rate went up there, the recidivism rate went down there, or up there, whatever, and all that. Blame the officials, credit the officials. Nobody's really going to know what to do. Second of all, I would suggest that because our criminal justice systems aren't very good at least one thing, rehabilitation. In fact, some argue that the most important thing a prison system can do to reduce recidivism has to do with the so-called reentry problem, smoothing the transition as people leave prisons. Why? Well, first of all, get them all settled, get them jobs and all that. But the real problem may be, of course, that prison itself makes people more criminogenic. No, it's not because they sit around trading notes on how to commit crimes. Maybe that's true to some extent. That's old movie stuff. It's more that you've already led a dysfunctional life. Your social trajectory is thwarted even more. Your ties to family, education, whatever, thwarted more. You may get out of jail more criminogenic than you were before, except at least you were older. Therefore, the goal of reentry should be, in a sense, to reduce the likely increase of recidivism that's the result of having been in prison. Okay. What does all this come down to? Let's be realistic. I would just suggest that, putting aside some of these details, recidivism really should be defined as an improvement. That holding constant age in this trajectory, at least the guy is less criminal than he used to be. And if you factor in maybe something like a cost-benefit measure, how many dollars of state money were spent to reduce the guy's recidivism by that much, that wouldn't be a bad way of testing efficacy. Thank you.
Our last speaker is Pam Karlan. Pam is the Kenneth and Harl Montgomery Professor of Public Interest Law, and she's the co-director and co-founder of our extremely successful Supreme Court Litigation Clinic. She's one of the nation's leading experts on voting and the political process, the law of democracy, if you will. Not only one of the leading experts, she and two others basically reinvented that field when they entered it. She's also served as a commissioner on the California Fair Political Practices Commission. Pam's also served as an assistant counsel and cooperating attorney with the NAACP Legal Defense Fund before she went into teaching. She's the author of many articles and many books. On a personal note, I've known Pam since I was a law student at Virginia. I have been in awe of all that she does so well for a very long time. You will see in a moment. One aspect of Pam that people don't always know is not only is she as accomplished as she is as a teacher, scholar, and advocate, but she's more capable of reciting poems from memory and being a stand-up comic than anyone else I know. So, Pam.
I'm so glad you're here. It's so great to see so many of you come back for your reunions. I love teaching torts. This is my second time teaching it, but I bet if you can't remember anything else from the classrooms you were in law school, you remember, if not the holdings of any of the torts cases, the facts. How many of you remember the flopper? Nobody remembers the photograph. You're nodding, but you don't want to raise your hand because you're still afraid you're going to be called on. Or Mrs. Paul's graph. Exactly. Or my favorite case, the only time I was cold called on in law school, a case called Barons against Bertram Mills Circus that begins with the following phrase that I remember better than any poem I've ever heard. Plaintiffs, comma, married midgets, comma, operated the funhouse concession at defendant's circus. So there's an awful lot that you remember about torts, and one of the things that I think everyone agrees about, my colleague Mark Kelman says this all the time, is the one thing that no matter how much we talk about changing law school, we all agree shouldn't be changed very much is the first-year classroom. That works spectacularly at giving people a sense of legal reasoning, whatever else is going on. So I thought I'd tell you about 3 innovations I've made this year in my torts class that are designed to preserve the old, but also to keep something about the new. The first of them is the materials that I use. You will all remember from law school case books. They are large, they are expensive, they are ugly, they have the planned obsolescence that GM abandoned in the 1960s so that they can be charged for again and again and again. They're 1,900 pages long, but you only read 700 pages, and the faculty member assigns them seemingly at random. Read pages 13 to 63, also note 42 on page 158. Not in my class. The materials for my class are completely free to the students. They don't pay a penny for them. They're electronic, and we use a casebook platform that's being developed at Harvard called H2O, because they're so clever there, right? If you think about it, H2O, get it? We think of ours as sparkling water by contrast. But the materials contain not just cases which either I or Jonathan Zittrain, who sometimes teaches here but has a permanent appointment at Harvard, have put together. That is, I've excerpted down all the cases, but I put them in an order that made sense to the students. So they start at the first page of the materials and they go to the last page of the materials. We don't skip things, we don't jump around, they don't have the sense that they're missing things. But if in reading a case they have the sense they're missing it, they just click on a button and the case expands so they can see what I edited out of the case. It's not just, though, that I've edited the cases, but I've included other materials right where we need them. So when we talk about a high-speed chase case and whether the police acted reasonably in stopping the case, they can click on the movie and they can watch the high-speed chase from the perspective of the cop car. Or when they read Riss against City of New York, which many of you will remember, the obsessive boyfriend who throws the acid in the woman's case, they can then click through and read the New York Times' obituary of Ms. Riss, where you find out she married the scoundrel later in life. And while the students are reading, they can highlight the materials, they can intersperse their own notes right into the materials, and they can retrieve all that stuff anywhere in the world at any time they want. Students can read the case book on their laptop, they can print it out, they can read it on their iPhone if they still have the good eyesight that they will have lost by the time they're in their 3rd year of law school. Plus, I can add in whatever other interesting materials I want. So in addition to common law cases, we read a number of Federal Tort Claims Act cases because I think those are interesting. And because so many students come to law school interested in the Constitution, we read a number of Section 1983 cases as well. So that's the first innovation. The second innovation is in how I expect students to take notes in class. The bane of the laptop world is that many of our students think they came to law school to be something other than a lawyer. Either they thought they came to be a stenographer and court reporter, and they try to take down everything, or they came to law school to be a shopper and a sports fan, and they try to watch things on their laptops. So in order to avoid this, one of the things I assign every day is a panel of 3 students to sit down and write a summary of what went on in class that I then post onto the class website, so you don't have to worry about that. It also, thank you. You've been a wonderful audience. Boy, are your arms tired. But it also allows me a check every day on whether the students are getting it or not. And so before I post the summaries, I and my teaching assistant, a 3rd year student here named Willie Cochran, write comments in bubbles in the margin, like, if this is what you think, you might also want to think about this, or this, or this, or this. And it gives us a kind of reality check as the quarter is going along on whether the students are getting things. We can suggest other things they might want to read or think about, or refer back to things we've talked about earlier. The final change is You all remember that you started law school in September, or for some of you perhaps in August. You got to December, and sometime in January or February, you got the first feedback on whether you were getting it or not. I don't think that's a good way to teach, and so during the course of the quarter, we give 3 writing assignments to the students, 3 optional writing assignments that they can read and turn in, and they will get individualized comments both from me and the TA, and get those back during the course of the quarter. Indeed, while you are all sitting here enjoying lunch, they are working on the first of those writing assignments. The writing assignments are designed only to benefit them, so they can count towards your grade at the end of the year if you do well, but they don't have to count if you don't. In the past, about 2/3 of the students in my first year classes do these writing assignments, and when I go back and look, about 50% of the time, the student's overall score for the course increases because of the writing assignments. So it's an option for them. If they want to gamble and not do them, they don't have to. But while you're here enjoying things, you may, if you stop by the library or stop by some of the wonderful workspaces on the 2nd floor of the new Newcomb office building, you may see some students hunched over looking worried. It's not because Stanford isn't a great place. It's because this is their first opportunity to get feedback. So thank you all so much for coming. I hope to get more of a chance to talk to many of you over the course of the weekend. And rest assured that we still teach Paul's graph, we still teach the flapper, we still teach Barons against Bertram Mills Circus. So if you're wondering what happened to the midgets, well, come back and ask some of the students next week. Thanks.
Many of us would like to go back to law school, I think, and have these 3 teach us. Thank you so much for coming. I'll see you throughout the course of the weekend. We're so glad you're here, and have a good afternoon.